Hello, and welcome to Ground Rules Employment Law Over Your Coffee Break. I'm Pam Howland, and I'm happy to have you here with us today. Today's episode looks a little different. We're bringing you inside our recent workplace investigations workshop. It was a full day packed with strategies and insights, and we thought it would be valuable to share a portion with you here on the podcast. Today, you'll be hearing from one of our newest attorneys, Megan Egbert, as she kicks things off with a critical question. Why should employers conduct workplace investigations? From legal obligations to protecting your organization, Megan breaks down the why behind investigations in a clear and practical way. So let's jump into the first 30 minutes of the workshop and take a look at why you would conduct a workplace investigation.
Okay, hopefully everybody got a seat. To the folks online, I wish I could say that the donuts don't look good, but they do. But you probably have the most comfortable seat. So, as Pam said, I do think this day is going to fly by. And if the entire training doesn't, I pretty much guarantee my part will, because I took the very easy beginning part. Right? I'm going to focus on why we do investigations. So we're going to talk to you today about a lot of stuff, but we're going to do it in digestible little pieces. And hopefully by the end of this training, you all will be able to answer why we do investigations, when we do investigations, how we do investigations, and who should be doing the investigations. But in the words of Simon Sinek, let's start with why. So why do we investigate? There's many reasons why you don't just need to, but hopefully will want to investigate. And that's what we're going to dig into a little bit today. Were any of you at the SHRM training or conference last week? Anybody make it to that? Some of you. Okay, yeah, quite a few of you. Great. So I was there as well, and I happened to go to the session with Zach Florent, who's the Outreach and Education Director for the EEOC. If any of you were in that session, it was great. And he was throwing out real life scenarios EEOC has seen. And the audience, we were all pretending to be the greatest HR firm ever. And we were working together in small groups to come up with what we thought the best answer was to each of these actual scenarios, right? And what was so interesting is one thing that was never the wrong answer in any single scenario that he gave was to do an investigation. Every single scenario could have benefited from an investigation. And in fact, as he debriefed on each of them, that was usually the very first step. The first reason why we do investigations is we have a legal duty to do them. And Pam talked a little bit about the EEOC guidance that we're going to refer to really throughout this training, I would imagine. And in 2024, so very recently, is when this guidance came out. And I did a little bit of digging into this, and it's so fascinating because this was the first guidance released on workplace harassment in 25 years. Can you imagine what has changed in the workplace in 25 years? So when we talk about the importance of this guidance, that's part of it. It's really significant, right? It also took 10 years, almost 10 years. I found the press release from 2015 when they formed the task force that started researching these issues to formulate this guidance. So that is how robust it is. And, it takes us a long time to digest it. So now we're hoping to put it in, really small bits for you to make your jobs much easier. But according to the EEOC, while anti-discrimination statutes seek to remedy discrimination and harassment under Title VII, their primary purpose is to prevent violations. But we, as employers, have to take all the necessary steps to prevent harassment, right? It's no longer enough to just have an anti-harassment policy. The policy is no good if you don't do anything about it. So this enforcement guidance passed by a 3-2 vote by the commission. And while it's not necessarily legally binding, it is the best thing we have out there right now to inform us on what exactly our legal duty is. So here's one of the findings, and I'm not going to go too depth into this because my very smart colleagues are going to talk more about this. I'm really just focusing on why we do evaluations, but some of that came up in their guidance. I think Jennifer's going to talk a little bit more about who should be conducting investigations, but part of our why is this language right here at the beginning. The EEOC said employers must have a complaint reporting system that provides prompt, thorough, and neutral investigations. In the legal world, must is not usually up for debate. It's not like, maybe we do that, maybe we don't, right? That's very definitive language. And so I think it's a pretty strong indicator that we need to have these processes in place and we need to be following them. Prompt, what does that mean? Sometimes I wish their guidance would have been a little more specific. What we know is that the next day is always going to be considered prompt. If you get a complaint or if you have reason to believe that there is a complaint and you start investigating the next day, you're good to go, the guidance says. We also know that 2 months from when you receive a complaint or have reason to believe that there's a complaint is not prompt. Anything else in between there is going to be fact specific, right? And that's like everything in your world, right? It's probably your least favorite phrase at this point is it's going to be fact specific, but it needs to be prompt. Some more of their recommendations. Again, we're going to get to all the details of how you're going to accomplish these things. But for now, this is what the EEOC recommends that we do. And although the language here is not a must, our best defense, as we're going to talk about today, to any claim is that we are taking their recommendations seriously, right? So we need to have this system. It needs to be done by a well-trained, objective, and neutral individual. And at the bottom here, I think this is another really important reason why we do investigations, to take all questions, concerns, and complaints seriously. So I just wanted to point out that language again, right? It's not saying to take the really, really bad ones seriously, the ones that on its face, you're like, ooh, we have a problem here. It's saying that we need to take all questions, concerns, and complaints seriously. Okay, final slide about their guidance here. In this one, so they're saying also, I just want to note that we need to appropriately document every complaint. Every complaint. And we're going to get into that more today too. But all of these together to me says that as employers, we have a legal duty. We must have these systems in place for our employees to make a complaint. We have to take every complaint seriously. And not just complaints. It says all questions and concerns as well. So that's why we have a legal duty and why we do investigations. But there's other reasons as well. And one of them is because, as Pam mentions, sometimes we end up doing litigation around these type of complaints. And if you've ever found yourself on the end of a complaint that ends up in litigation, one of the things that we have to be very aware of is whether or not you have a defense to the complaint. And I'm just going to briefly explain these 2 Supreme Court cases that made up what's going to be your very best defense. And then we'll talk a little bit more in the next slide about them. But in 1998, incidentally, on the very same day, the Supreme Court decided 2 employment discrimination cases. The first one being Farragher versus the city of Boca Raton. And in this one, for 5 years, the plaintiff worked as a lifeguard. And after she resigned, she brought an action asserting claim under Title VII, alleged that throughout employment, two of her immediate supervisors created a sexually hostile environment for herself and other female lifeguards, touching remarks, just very inappropriate behavior. And the lifeguard worked out of a beach office with these supervisors and had no contact with senior managers. So the people who were doing the harassing were her managers. And the city had actually adopted a sexual harassment policy during this employment, but it was never disseminated to the lifeguards. So it never made its way down to the employee who was actually experiencing this conduct. And in the 5 years that she worked for the city, the plaintiff did not report the supervisor's conduct to managers above the supervisors in the chain of command. But the Supreme Court said that the city did not have a defense to this conduct because they failed to disseminate its policy against sexual harassment. They failed to keep track of the supervisor's conduct, and the fact that the city's policy did not include any assurance that a harassing supervisor could be bypassed, what to do if your own supervisor is the person doing the harassing conduct, was not addressed. So they essentially said she had nowhere else to go. You don't have a defense to this claim, and they found them liable. And then the second one was Burlington Industries, Inc. versus Ellsworth. Again, same day in 1998 that it was decided. And the plaintiff in this one had a supervisor who made really offensive remarks during a 14-month span and also allegedly threatened to deny tangible job benefits. So would say things like, I could make your life very easy or very hard. So that type of sexual harassment. However, the supervisor did not carry out the threats against the plaintiff, and indeed, she actually received a promotion during her time working there. She never reported it, but brought an action alleging sexual harassment after she resigned. So similar to the lifeguard, right? Upon resignation, said, actually, I have this complaint. And the Supreme Court here found that the employee's failure to use the complaint process can be proof that they did not try to avoid the harm. So in this case, they actually had a complaint process, and the employee did not use it. So they mixed these two cases kind of together. And what we have now is the Farragher-Ellsworth defense. And to establish this defense, an employer must show, again, it's a must, that it exercised reasonable care to prevent and promptly correct harassing behavior, and that the plaintiff employee failed to take advantage of the employer's preventative or corrective measures or otherwise avoid harm. And it's a both, it's an and, right? So you need to do both. And the key to this defense for employers many times is going to be a prompt and thorough investigation of a complaint. So that is the second reason why we're going to want to do an investigation, is to have a defense against a claim. And then the third reason that we want to do investigations, what do people think of when they think of punitive damages? Any idea on this one? It might be a term you've heard thrown around before. I always think of the term punish, right? Punitive damages. And in fact, that is what they are, right? So punitive damages are considered punishment, and they're typically awarded at the court's discretion when the defendant's behavior is found to be especially harmful. And a complaining party can recover punitive damages under some Title VII claims. But the key here was in this case called Kolstad versus American Dental Association, that an employer may not be liable for the discriminatory decisions of its managers where these decisions are contrary to the employer's good faith efforts to comply with Title VII. So if the employer itself is taking good faith efforts to comply, then it's going to take some of these punitive damages off the table. And just to give you an idea, so I looked up in Title VII, there are limitations to punitive damages. But just so you know, this is outside of when we're talking about things like back pay, front pay, other types of relief that employees could get in a claim. This is outside of that context. And there are some limits on them, but they're pretty steep, right? So if your workplace has 15 to 100 employees in it, that's a pretty good size, then an individual claimant is going to be limited to $50,000 in punitive damages. That's the maximum that they could seek. If you're between 101 and 200 employees, up to $100,000 in punitive damages. 201 to 500 employees, 200,000, and then 501 or above, $300,000 max in punitive damages. And here's the real kicker, is that that's per individual. So if you have where multiple employees have a claim against you, then they could each get that amount. So punitive damages is one of the reasons why we want to do investigations, because it's going to demonstrate as an employer your good faith effort to comply with Title VII. If you are taking those complaints, questions, and concerns seriously, and if you're doing your due diligence that you can as an employer. And then another reason why we do investigations is something that I'm sure you're all familiar with, which is a whistleblower claim. So like a claim of retaliation. And this would be where an employee is participating in a protected activity. And most often that might be something like they are making a complaint to you about something in the workplace. And then an adverse action happens. The key here is whether or not a causal connection can be shown between the two as to whether or not they have a whistleblower claim. So somebody makes a complaint, right, of some sort of harassment in the workplace, and then a week later, they are transferred to a different job. Obviously, there's going to be a lot of questions around this, but there is some action taken. It's possible that it had nothing to do with the complaint that they made. But how are you going to demonstrate that, right? And this is why we do investigations, to start to dig into these questions of, was there a causal connection at all between these two things that happened? And that's going to be your very best defense to any sort of whistleblower claim, is if you already have looked into it, if you've done an investigation and you can say, nope, actually they were totally unrelated. The people who made the decision about the transfer had no knowledge actually about the protected activity that this employee took. This is just a little bit from Idaho Code 6-2104, which is our Idaho whistleblower language, but it's for public employees only. But just to note in this, where it says, such communication shall be made at a time and in a manner which gives the employer reasonable opportunity to correct the waste or violation. Even if you're not in the public sector, I think this language is still really important of how we think about these type of notifications, right? Is that it's giving you an opportunity to correct something. So a complaint of harassment or discrimination is not the only trigger for investigation. Does anybody have, and we're going to go through a slide in a minute with some other examples, but can anybody just off the top of their head think of other things that might trigger a need for an investigation? Yeah. Employee surveys, that's so good, right? You had no idea that you were asking for as much information as you got, but you put an employee survey out about maybe professional development. And all of a sudden you have people saying, well, I've never gotten an opportunity for professional development, but so-and-so has gotten like 18 opportunities, right? Whatever it is, it might not even have been the intent of what you were seeking feedback on, but all of a sudden you have some information that you need to find out more about. That's a great example. Yeah. Anybody have other ones as well? Yeah. Yeah. an exit interview. What do people think? Is an exit interview, is it too late? Like, yeah, okay, good. Exactly. Yeah, exit interviews are a great opportunity that, wow, that doesn't sound like it quite matches with what our personnel policy is. I think we need to do a little bit more digging on what happened there. Yes, back there. Oh, that's a good one. Yeah. So it's time for an employee's annual review. They get to put their own comments in there. And there's some reason for concern based on what an employee puts in there, or at least there's reason to do a little bit more digging, right? That's a great one. Any final thoughts? Yeah. Medical leaves? Yeah, tell me more. Why could that? Yep. It's a great example, right? Just normal request for medical leave, but there could be a lot more to it. So here's some other examples too. This is not an exhaustive list, but what I like about some of these, we've talked about them, right? Harassment, discrimination, retaliation, obviously those ones. But I think this is so interesting, like time card violations. Why do you think time card violations might spark a need for an investigation? Oh, sorry, not that one. The employee theft. Well, yeah, I mean, yes, it could be viewed as that, right? It could be viewed, yeah, there could be some theft happening. You're stealing, the employer's dollars for time you're not actually working. Did you have one too? Yeah, what if an employee is altering their schedule because they're so uncomfortable around somebody in the workplace? That's a good one I hadn't even thought of. Yeah, great. I also think, like, what if they're having a medical issue, right? That you need some more information about, right? Like, what if every morning, something is happening before they reach the workplace that's causing some of these violations as well? Or it's really hard to know, but some of these are not as expected, right? Bullying and disrespect, that can be really fuzzy, right? But how do you know if something has actually crossed that line to where it violates your policy, or if it violates a state or federal law if you don't look into it? And how do you prevent it from getting to that place, right? Like, maybe it's actually just an employee who's making snarky comments to another employee, and it doesn't quite meet an anti-bullying policy if you have one. It doesn't quite meet the threshold for harassment. But do you have an obligation to step in before it gets to that point? I would say arguably yes, certainly if you have notice of it. And ultimately, as employers, we always want to show that we've treated employees fairly, that we have good policies. I know you all probably have good policies. You probably have amazing handbooks. If you don't, you're going to contact us after this, and Emily's going to make sure that your handbook is phenomenal. And we also want to show that we consistently have enforced and followed our policies. And the final reason why I'm going to talk about we want to do investigations is this idea of what would a jury think. And I'm just curious, have any of you ever been on a jury, a member of a jury? Got 1, 2, 3, 4. Okay, I wish we could talk about this all day because I find juries fascinating. And I was a juror on a federal trial for 2 weeks about sweet potato French fries. So I'm kind of an expert if anybody has questions. But I'm just curious, if you've been on a jury before, what was your perception of the jury? Would you want them making decisions about you as an employer? No. I mean, did anybody think, like, yes, my jury was really credible and like did phenomenal work? Yeah, my jury was horrible. Okay, we were told for 2 weeks all the things that we could not talk about in the jury deliberation. And I think we were in deliberation for like 2 minutes before the first person brought up like one of the things that we were not allowed to talk about. It was fascinating. But I think about this a lot because if you see some of these cases go to trial, you have to think about what would a jury think. And I worked for an entity before who made the difficult decision We were a public entity of we needed to switch our schedule and be open on Sundays. And this was a very difficult decision for where I was working because we did have a lot of people who had a religious belief that prevented them from working on Sundays, or at least prevented them from working some specific times on Sundays. And so as we were carefully going through that process, we started off by just asking people about their availability, right? Like we were just putting it out there. Who has availability on these days? Because it wasn't custom that we had already been open on that day. And we found that about a third of our staff had a conflict on Sundays. That was how we kind of started it. But we had one staff member that we were really having a hard time with already. Performance, attendance, they'd been on a PIP, everything. And when you work with people, you kind of get to know them, and you kind of get to know their schedules. And this person had no known conflict that we knew of, and no known, sincerely held religious belief that would prevent them from working on a Sunday. But who was the first one, who said, "Yep, I can't do that." Like I have, a conflict and a religious belief that prevents me from working on Sundays. And it felt a little bit like an eye roll moment for some of us. And there was part of us, and there was conversation that was like, do we have to go through this whole process with this person, right? Do we have to go through the motions when they've already said that they have all these other things that are happening on all these other days? Do we have to go through the process? What was fascinating is we went through the accommodation process, like I said, with about a third of our staff, and we came to a workable solution. But guess who the one person was who ended up making a complaint about religious discrimination? It was the person that we did not want to go through that process with. And so I think about this all the time. We had some information that formulated this belief that this wasn't a credible, it wasn't a credible ask. But what would a jury think if they're like, wait, you didn't even, go through this process with this person? Like, how does that look? They don't have the insider knowledge. They don't necessarily know about the years and years of, whatever this employee has done. It looks horrible, right? And luckily we were able to resolve the situation far before it ever, came up before a jury. But I think that always has to be back in the back of our heads of what would a jury think if this got to before them and we didn't even do an investigation. Okay. I think I said final reason already, but there's one more. Also, we do investigations because you all have phenomenal policies, or you're going to talk to us afterwards. And in them, it says that you have a complaint process. This is just a snippet of ours. Our complaint process is much, much longer than this. It's enumerated under this and goes into detail of what that process is. Hopefully yours does as well. But because it's in our policies, then we're going to do it, right? We're going to follow through on what we say we're going to do. And then finally, Pam alluded to the fact that the EEOC is kind of in a transition phase right now, and some of their priorities are shifting, right? And so I just wanted to highlight that a bit as well. This was a press release just from March of 2025 that the acting chair of the EEOC had sent letters to 20 law firms information about DEI-related employment practices. And then also comes from a one-page from the EEOC that came out just like a month or two ago that has to do with what to do if you experience discrimination related to DEI at work. I highlight this because it might be a different shift from what the focus of the EEOC has been in the past. And it might be a shift from some of your own employment policies, but an investigation is a great opportunity to check if your own policies align with what we're seeing in the larger society right now too. And those aren't the only reasons why you might investigate. And we're going to hear more about that today as some of the speakers come up here. Maybe a claim arises and there's no documentation at all to support that legitimate non-discriminatory reason that it actually happened, right? We talked about that a little bit earlier with whistleblower claim, this causal connection, but maybe there was a perfectly good reason why somebody was terminated or not hired or not promoted or transferred or whatever the complaint is about, but there's no documentation about it. An investigation is going to allow you the opportunity to ask the people who know those reasons. Ideally, they would already have documented it, but maybe not. And so you're going to ask those questions. You're going to build a record of exactly why this decision was made. A third-party assessment of credibility can help counter the he said, she said. Perhaps there was an incident where there was only two people, and it's this kind of he said, she said, she said, she said, he said, whatever situation. An investigation, whether it's you doing it or an outside person doing it, can kind of assess the credibility of those two encounters of the same situation to help you decide which way you're going to lean in taking action on the situation. An employer investigation may look biased, and the Idaho Human Rights Commission may defer more to a neutral professional. So like I said, we're going to talk about that later when we talk about the who should be doing it. But sometimes an internal investigation might not be the right answer, and we're actually looking for an external one. And then number 4, which is bolded here, is that the investigation could be a key piece of evidence used to defend a claim. Right? So this could be your best defense against a claim, is actually partaking in an investigation. I think that's the end of my slides. Yep. And now Jennifer is going to talk a little bit more about how to conduct a workplace investigation.
That wraps up today's episode of Ground Rules. We hope Megan's session gave you a better look at the real reasons why investigations aren't just helpful, in some cases they're essential. The full Workplace Investigations workshop recording will be available for purchase in about 2 weeks. If you'd like detail, reach out to us at contact@idemploymentlawyers.com, and we'll make sure you get the information. Thanks for listening, and be sure to join us next week for another episode of Ground Rules, Employment Law Over Your Coffee Break. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.